Hi everyone, this is Bob. I'm a JD candidate at Victoria University School of Law. Disclaimer, I want to put a disclaimer before I proceed with this video. I'm going to talk about civil proceedings, but civil proceedings are very wide, so I'm going to give you a small hint of civil proceedings. In that, I'm going to talk about how to file a civil lawsuit in Uganda. So I'm going to break it down. Now let me proceed. Civil proceedings in Uganda are guided by the Grand Norm, the Constitution of the Republic of Uganda 1995 as amended. But we have the main statutes that we use. That is the Civil Procedures Act, CAP 282, Laws of Uganda, and the Civil Proceeding Rules, Statutory Instrument 71(1), yeah, and others. I may skip others, I think, to just make this precise. So, civil procedure, a civil matter is a one-on-one matter. For example, Bob versus X in the matter, not the other way around in criminal proceedings, where in a criminal matter where you find the state is versing Bob or X. So, proceeding to file a civil lawsuit, when a client approaches an advocate, the first thing to know, a client will come telling you that I demand so and so 70 million. We plan that he or she should have paid me on this date, but it's past. So there you have to file or issue a notice, a demand notice, and that demand notice in law is called a notice, an intention to sue, a notice of intention to sue. When you read that demand notice, you expect two things: a reply to demand notice or no reply to that demand notice that you have written. Where a party, the defendant, has written a demand notice to you but has replied to you on the demand notice, know that you may sit down and solve the issue amicably, whereby you tell him, okay, now start paying my money, the installment, so what. But where there is no reply on that demand notice that you sent, then just know that you're going to proceed to court. I'm going to give you a live example that recently happened. Bebe Cool, through his attorney, through his barrister, wrote an intention to sue to Alex Muhanji, but their side, because they are the defendants, they didn't reply to that letter. That's why you are seeing them in court right now. I think you have understood that very well. So after there, you draft a plaint. And when you're drafting a plaint, you are guided by as I told you, you are guided by the rules, the civil procedure rules, and you are guided by Order 7, Rule 1, which emphasizes on what should contain on the plaint. When you go to Order 7, Rule 1, it emphasizes on what should contain on the plaint. And one of the things that should contain on the plaint is the cause of action. The cause of action will drive you to the jurisdiction. When you know the cause of action of the matter, it will give you the pecuniary jurisdiction, it will give you the territorial jurisdiction of that exact matter. When I talk about pecuniary jurisdiction or territorial jurisdiction, I mean the area of where the cause of action happened. Let's say the cause of action happened in Tinda. I don't expect an advocate to go to Kamwenje, the Chief Magistrate of Kamwenje or High Court of Kamwenje. That's the territorial jurisdiction. Then there is also the pecuniary jurisdiction. I think that should be the first one, because if the matter is above 50 million, that's High Court. 50 million, that's Chief Magistrate. 20 million, Grade 1, Grade 2, according to the money that the plaintiff is demanding the defendant. So I'm going to define for you what a cause of action is, because it was defined in the famous celebrated case of David Tinyefuza versus Attorney General, and even this case of Dr. Chizabesige versus Attorney General, where court defined a cause of action to be a set of facts that when one proved them to court, one is entitled to get a judgment from court. And you go far as breaking down a cause of action into its elements that were brought up in the celebrated famous case of Auto Garage versus Motokovo, a case of 1971, which provides elements of a cause of action. And I'll proceed to read to you that in a cause of action, one should have enjoyed the right, should have breached, and should be breached by the defendant. So that is cause of action. After that, you file your documents very well, you take them to court, you file an affidavit on those documents, then those after attaching the affidavit, of course they are received by the judicial officer, and then on time of service they are served by the process server. So today I will stop here, at least when the case is on that level of being served by process server. Then court sets a date of hearing the matter. So if you want my detailed video of how to file a civil lawsuit in Uganda, you will go to hugoentertainment.com. I uploaded a full detailed video that contains everything that you need to know. Thank you.